Thank you very much, Mr. Deputy. Mr. Deputy, it is again a privilege to stand in this honorable place to represent the good and special people of the East Grand Bahama constituency. And Mr. Deputy, I hope that the remarks that I give will be done soberly, and that with the seriousness of the issue that we are facing. I want to start, Mr. Deputy, with a quote. And this quote says, "Until our system is fixed, however we tweak the Bail Act will not prevent the grant of bail to persons charged with serious offenses." The only answer to this vexing question is to be able to try persons within a reasonable time. That's the long and short of it. These comments were made in October 12, 2011, in this honorable House during a debate for a compendium of bills, including the amendment to the Bail Act. Mr. Deputy, until our system is fixed, however we tweak the Bail Act will not prevent the granting of bail, or I would add, would not prevent the revocation of bail. The only answer is to fix, I will address it. The only answer is to fix the system with a view to trying persons within a reasonable time. Let's allow that to sink in just for a few seconds. And in response to the member for Exuma, I will come back to this quote a little later in my presentation. Dame Anita Allen, a well-respected former judge, former president of the Court of Appeal, and who presently serves as the Law Reform Commissioner, made several comments that I believe we all should take note of. And these comments were made publicly. They were published in the news as an opinion piece. And she is the person who is responsible for advising the government on all laws that will come to Parliament. She makes some observations that I would like to expand on. Those of us, and I quote her now, those of us who thankfully until now are untouched by the violence are nevertheless afraid to leave our homes. But even more daunting, we are afraid to stay in our homes. Mr. Deputy, this is a very real emotion and circumstance that all Bahamians, particularly in New Providence, can identify with. People are frightened to leave their homes, and people are frightened to stay in their homes. The fear of crime is real and needs to be dealt with. Mr. Deputy, the courts have for many years dealt with bail, even at the common law level. And the Supreme Court has been able to administer bail applications. That is, the Supreme Court administers the granting of bail, the refusing of bail, and the revoking of bail. I do note the Prime Minister's comments this morning. The judges retain their discretion, even in the midst of this amendment. But, Mr. Deputy, I do not agree on this. Because the Supreme Court bail, which was granted, will be automatically revoked or made void. This, in my view, imposes the legislative view for the judicial view. It deprives the person from being heard on the question of bail before the bail is revoked or made void.
The chair recognizes the honourable member for Freetown.
That's exactly what the bill does not say. The bill says that the recognizance is void, that the prosecutor has to apply to the court to revoke the bail, and has to give the person who is on bail 7 days' notice of the hearing.
Thank you, honourable member.
Again, Mr. Deputy, what happens with respect to this amendment is, once the person is, and what the amendment says, the amendment 9A sub 3, that once the person is in breach of a condition of bail, their bail is void.
Yes.
Our difficulty with that section is the bail is made void without the person being heard on that question of bail.
Why?
The bail is automatically revoked once the person breaches a condition.
That's not true.
After the court finds that the person is guilty of that offense, the Prime Minister said this morning that the offense automatically causes the bail to be void, which means that once you go before the magistrate court says that you are convicted of breach of a bail of condition, according to this amendment, the bail is void, which means you are locked up right then and there. That is, again, what I understand the Prime Minister said this morning. Then, he then said that you would then have to apply to the Supreme Court. You would be held in custody, and then you would then have to apply to the Supreme Court to apply for a new bail.
Yeah.
The difficulty with that is, once the bail is revoked or made void, it is revoked or made void without being heard on the question.
It's void without being heard. It's revoked on a hearing.
It is void, and it also, as far as the Prime Minister stated today, because again, the Prime Minister said today, now if you want to get up and say that the Prime Minister was wrong in his assessment today, that's fine. But the Prime Minister said today that once you are convicted of an offense, he said once you are convicted of an offense, your bail is void and you are going to jail. Your bail is void and you are going to jail without having a hearing. Mr. Deputy, that is in essence the difficulty with this bill, is that you are going to jail without having a hearing. So, allow me to continue. Mr. Deputy, the court has an unlimited discretion to admit bail. I would submit that they have an unlimited discretion to admit to bail, they have an unlimited discretion to deny bail, and they also have an unlimited discretion to revoke bail. Before 1994, judges in the Bahamas used English common law, which gave them the power to use their discretion to grant, to deny, and to revoke bail. In the Attorney General and Ferguson, which is a Bahamian Court of Appeal case which was dealt with in 2009, the Court of Appeal referred to Baronet and Allen, which is an English law case. And I quote that English law case. I do not think that the accused party is detained in custody because of his guilt, but because there are sufficient probable grounds for the charge against him so as to make it proper that he should be tried. And because the detention is necessary to ensure his appearance at trial, the court has at all times an unlimited discretion to admit to bail. That's what the law says. The Court of Appeal also goes further to state what the role of Parliament is in making laws as it relates to bail. Yes. And I wish to remind us what the court said our role is as it relates to making laws when it comes to dealing with bail. Our role is to set general standards, for example, criteria which the court can consider. And I quote from the judgment. The second decision was won by me, and this is the judge talking, in Benaby and the Commissioner of Police, number 28 of 1995, in a judgment delivered on the 15th of May, 1995. In that case, this is the judge talking, I came to the conclusion that Section 4, as it was then worded, was in conflict or was not in conflict with the Constitution. In the course of giving that judgment, I also pointed out that while Parliament, by legislation, may set general standards, for example, the criteria which are to be taken into consideration by the court when deciding whether to grant or refuse bail. Again, my understanding of what the court is saying is that as far as legislators, our role is to provide a general standard as to what the court should be taking into account when the court decides whether or not to grant bail, whether or not to deny bail, or whether to revoke bail. So I ask the question, Mr. Deputy, through this legislation, are we setting general standards? Right. It does not appear to me that we are setting general standards. Anytime you say automatically revoked or automatically made void, my understanding is you are not setting a general standard or giving criteria as to what the court should take into account. Are we giving the courts criteria? As I said, I don't believe so. But, Mr. Deputy, here is what the court said we should not be doing. And I quote from the Court of Appeal case. If by such legislation Parliament sought to mandate how a court is to deal with a particular accused person, that would be impermissible use of legislative power, as it would amount to legislating ad hominem. And they refer to a case, Lineage and others, and Regina, an English case of 1966. I also, and I quote from the case as well, I also pointed out that the grant or refusal, and I would submit revocation, so grant, refusal, and I would submit revocation, bail is a judicial function, and for Parliament to seek to exercise that function in any way, particular case, would also be impermissible exercise of legislative function. To decide on whether someone is going to be granted bail, whether somebody is going to be refused bail, or whether somebody is going to be revoked, their bail is going to be revoked, is a judicial function. As far as Parliament is concerned, we provide a standard. We provide the criteria. But in terms of making that decision is a judicial discretion. And my submission is, by you automatically making the bail void, or your previous amendment was revoking, but you changed it to being made void, you are making that decision. That is a judicial function and not a legislative function. If the court had the discretion before the Constitution, then the discretion cannot be fettered. The Court of Appeal goes further. A third element, which was not mentioned by Frank Further, J., but which arises in the case of Section 4(2) of the Bail Act, is that there is no provision in that section for a judicial officer to even consider the evidence linking the person to the commission of the offense, and fourthly, that the subsection makes no allowance for the grant of bail where the detention of a person charged with the exact. So in other words, the section did not give or allow for the judicial officer to be able to make that decision. So our issue with Section 9A3 is it makes it void without allowing the judge to look at the criteria before it is made void. Mr. Deputy, I would submit that there does not appear to be an element in which a judicial officer can consider anything before the bail was previously revoked, but now you changed it to void, before the bail is made void. The judge has no say in it according to your amendment. So, again, Mr. Deputy, I go further in a case of Bartholomew Pinder and the Queen. This is a 2021 case, Court of Appeal case, our Court of Appeal case. And this case specifically dealt with revoking bail. So this was a case that dealt with where somebody already had bail and what the court decided in terms of whether you could revoke that bail. The Court of Appeal stated that whether or not Section 12 existed, there's always been an inherent jurisdiction of the Supreme Court to grant and to revoke bail. So whether or not the statute spoke to revoking bail, there was always an inherent jurisdiction for the Supreme Court to be able to revoke bail. They always had that discretion. The court also made it clear that there was no distinction in whether to grant bail and the revocation of bail. So as far as the Court of Appeal was concerned, the process of revoking bail is the same as granting bail. And I quote the Court of Appeal saying this: "In my judgment, the nature of the inquiry, whether to grant bail, is not materially different from the inquiry whether to revoke bail already granted." So they're saying the process and the application to grant bail is not materially different from the process to revoke bail. So if you cannot fetter a judge's discretion in an application to apply for bail, then you cannot fetter a judge's discretion when it comes to revoking bail. In both instances, and I continue with the quote, in both instances, it is an inquiry as to whether a person who is at large pending a trial should be deprived of his liberty pending trial. In both cases, we are talking about depriving somebody of their liberty. So we are talking about materially the same process. It is not simply a factual inquiry whether the accused has breached conditions already imposed. There may be reasons for that breach. Furthermore, rather than revoke bail, a judge could continue the bail and impose different conditions. So, Mr. Deputy, if the court's view that granting bail and revoking bail is the same, I would submit that Section 9A, subsection 3, cannot automatically make bail void. I then move to Section 12B(1). You have also sought to remove the court's ability to fine in a case where you are convicted of the offense of breaching the condition of bail. I would like to understand, though, how many of these matters have actually been prosecuted. I think it would be good to know if we are changing or we are attempting to change the sentencing with respect to persons who have breached bail. We ought to know how many persons have breached bail. Under what circumstances have they breached the bail? Secondly, of those who you've prosecuted, how many convictions have you had? And out of those convictions, how many have been fined and how many have been imprisoned? Now, I hear your comments that many persons have been fined, but it would be good to have the statistics as to you've had 100 people who have been convicted. Out of those 100 convictions, only 10 have gone to prison and 90 have been fined. It would be good to have that information when you are deciding whether or not you are going to take away the court's ability to fine. While we understand also the removal of the fine in this case and the government's intention for there to be a prison term, I ask the question, doesn't Section 115 of the Criminal Procedure Code still apply? Because Section 115 speaks to what the magistrate court, what sentencing the magistrate court can give. And according to Section 115, you can sentence someone to, in fact, they say sentence someone to death, but you can fine someone, you can sentence someone to prison, you can add costs to them. But if Section 115 still applies, then how does that Section 115, how does that correlate to what you are attempting to do here? Because you are attempting to take away the court's ability to fine. But in the CPC 115, it already gives the court the ability to fine. This would, and then also, Mr. Deputy.
The chair recognizes the honourable member for Fort Charlotte.
Is this a point of order?
Yeah.
No, I mean,
The chair recognizes the honourable member for Fort Charlotte.
Do I have to establish my point of order with you?
Honourable members.
Mr. Deputy, the question, as I understand it, that has been raised is whether the effect of discharging the bail is as a result of a legislative effect, or thus interfering. In other words, whether it's a statutory revocation, thus intruding on the judicial discretion. No. Mr. Deputy, it's a very simple distinction that the bill contains. The bill contains two elements. One is an agreement, and this is an agreement between the accused person who has the presumption of innocence, and it is the interest, on the other hand, of the society who has an interest to be safe from interference if one is a witness or in the administration of justice. As I read the bill, Mr. Deputy, the bill contains two elements. One are the relevant provisions amending the substantive Bail Act, and the other is a recognizance. Now, what is a recognizance? In law, what is a recognizance? What a recognizance is, Mr. Deputy, the recognizance, the recognizance, I'm not slated to speak. This is a very simple point, Mr. Deputy. The recognizance is an agreement. The recognizance is an agreement between the accused person who gets the bail on conditions, and the accused person agrees to the condition. And this is what the accused person in this recognizance would agree to. Conditions. Conditions. This is an agreement now. This is not the Parliament. This is the form of the agreement that the Parliament has framed, but this is the agreement entered into between, Mr. Deputy, I just want to make a very simple point. The agreement between, but you're interrupting me. The agreement between the accused, and the court. Recognizance. It says here, the conditions of the above written recognizance or obligation is such that if the said, and the name of the accused person is inserted, shall attend upon the court of or the Supreme Court or Court of Appeal Magistrates Court, until the charge, whatever that charge is, are determined of and observed. These are the conditions, please. I'm speaking to the speaker. The condition not to commit, the condition not to, please. I mean, the condition.
Honorable member, let him wrap up. Yeah.
The condition not to commit an offense, the condition not to make, the condition not to commit an offense while on bail for the offense herein. That's the first condition. The condition that he shall appear at the time and place of trial, or if an adjourned hearing, and not depart the court without leave. And any of the conditions specified, then this recognizance, Mr. Deputy, please.
Yeah,
please,
well, he's
Mr.
wrapping
Deputy.
up right now, Honorable Member.
Please, Mr. Deputy.
Honorable Member, he's
Please,
wrapping up
Mr.
right
Deputy.
now.
Please.
Yeah.
Your time, you're entitled to your time.
Yeah.
This has nothing to do with your time.
He's wrapping up right now, Honorable Member.
Every time you stand up, he
I mean, what happened? Why are you fearful of what I have to say? Mr. Deputy.
Let him wrap up, Honorable Member.
Mr. Deputy.
East Grand Bahama.
Mr. Deputy. And then it goes on to say, then this recognizance shall be void and the bail revoked. But otherwise, this recognizance shall remain in full force and virtue. A recognizance is that the accused person signs this, and by virtue of this agreement, the accused person, party to this agreement, says that the bail is void. In other words, it is an agreement between the accused person and the court, and the accused person signs it. It's signed by the accused person, the sureties, and the court. So the voiding, Mr. Deputy, is as a result of an agreement entered into between the accused person and the court.
Thank you, Honorable Member.
Thank you very much, Mr. Deputy. Y'all understand.
Mr. Deputy, on section, on your new section 12B1, I also wish to point out a law that the PLP passed to abolish mandatory minimum sentences. And I quote, where a provision in any law has the effect of requiring a court to impose a minimum term of imprisonment, that provision, to the extent that requirement shall have no effect. This does appear to be on point because you are requiring the court to order a prison term. So, Mr. Deputy, I do not think this would still give a magistrate the ability to fine in appropriate cases. I do not think that the removal of the $50,000 fine takes you any further. I also want to read something that our former colleague and late former Minister Bernard Nottage said when he said that in this place, when he spoke about the same law that brought into effect this offense of breaching a condition of bail. He said, so this law is an amendment to the Bail Act and is creating a violation of bail conditions to an offense which on summary conviction exposes you to be found guilty to a fine not exceeding $50,000. Now, this is not a mandatory $50,000, and this is the importance that he said. The judges have indicated they are not legally bound by mandatory penalties, but the amendment says that you could be fined up to $50,000. I then wish to discuss also the case that Carmichael raised this morning, the Tassi case. It's a Court of Appeal case, where in that case, and it's an interesting case because in that case, it was two offenses for breaching bail. One was serious and one was not. And it provided a distinction between when it is not serious and imposing a imprisonment is harsh, and when it is an appropriate time to impose an imprisonment. This is what the court said. A sentence for a single instance of appellant failing to charge his electronic monitor cannot be the same as a sentence for multiple breaches of the curfew condition found in count 2. The sentence must be proportionate. In our judgment, the sentence imposed with respect to failing to charge the electronic monitoring device is unduly harsh, and in that case, he was given a prison term. It could only warrant a modest fine, in which the failure to pay would result in incarceration of less than 1 year. We would impose a fine of $5,000 or 2 months in prison. As the appellant has already spent the time in prison, that fine was vacated. Here's what he says about the more serious one. The 1-year sentence for count 2 is not unduly harsh. The breaches were egregious, and the instances the breach reflect a complete disregard for the conditions of bail, and the punishment for the breaches of conditions of bail must reflect the severity. So,
Read paragraph 25.
I got 2 minutes. So, Mr. Deputy, allow me to finish, and then I'll move.
The chair recognizes the honorable member for Fort Charlotte.
No,
So on a point of order,
Mr. Deputy.
because
No, Mr.
25
Deputy.
is more relevant to this debate. 25 is more relevant to this debate. In other words, look, on a point of order, Mr. Deputy, on a point of order, paragraph 25. This is the Court of Appeal of the Commonwealth of the Bahamas. In our judgment, it is imperative that persons on bail fully understand that the conditions upon which they are released on bail must be complied. Prior to 2016 amendment, a breach of conditions could only result in the revocation of their bail. But by 2016 amendment, not only can bail be revoked, but they can be further punished for the breach as a criminal offense. The severity of punishment prescribed by Parliament reflects the gravity which Parliament and the society on whose behalf it enacts laws regard a breach of bail condition. The court must reflect that gravity in the punishment. In other words, this is yes, but the point precedes that. Of course, I mean that's elementary. That is elementary, my honorable colleague. That is an elementary point you make. The point you make is that the conditions of bail and the breach thereof has consequences.
The point I am making is that the Court of Appeal saw a difference in terms of punishment. They saw that there were circumstances that when you breach the bail, having someone incarcerated is harsh. And they also saw that when you breach the bail and there was a serious breach, that a imprisonment was warranted. They saw that there was a difference. They saw that it was a point where you should be fined for breaching bail and a point where you should be imprisoned. You are taking away their ability to fine. And they say there are circumstances where fining someone is appropriate.
Honorable member,
That's what they say.
The chair recognizes the honorable member for Fort Charlotte.
It is very clear in this amendment, if someone breaches bail within a 48-hour period, that person has to be presented to a magistrate. And the magistrate can either, not the Parliament, the magistrate can either revoke, impose bail on other conditions, or give new bail.
The chair recognizes the honorable member for Marco City.
The member for Fort Charlotte said that was not his interpretation. It means that he is debating one interpretation
Our colleague from the East is debating another interpretation. That's what parliamentary debate is. He cannot stand on a point of order to debate when he has a slot that he could go ahead and debate his separate interpretation. He didn't say it was misleading. He just said, it is an interpretation. And so if he's bored, they should give him additional work, but he should not continue to interrupt the colleague in making his presentation. He has a chance to speak.
Allow me to complete. I think I made that point. And I wish to also make the point that, and it takes me back to the first quote that, because I do want to make that point, that it takes me back to the quote, until our system is fixed, however we tweak the Bail Act will not prevent the granting of bail to persons charged with serious offenses. The only answer to this vexing question is to be able to try persons within a reasonable time. That is the long and short of it. Well, the person who made this quote was none other than the member for Cat Island, the Prime Minister, Philip Davis, when he spoke on the Bail Act, the amendment to the Bail Act in 2011. Mr. Deputy, very quickly, the present Law Reform Commissioner is saying what we need to do. She did not recommend changing the Bail Act. I suggest, and I quote from what she said in a public presentation, I suggest the increasing the numbers of public defenders. This we can do now. And the panel for jurors. This we can do now. Improving the process of summoning. This we can do now. Selecting jurors, providing protection for jurors, increasing the capacity of the public forensic lab. I believe that we are doing that now. Fewer pre-trial adjournments. This we can do now. Better time management for trials. Can we also do this now? Weeding out the backlog in the system, stricter compliance with laws and rules of procedure by all actors. This we can do now. Additionally, she also made two other proposals. One was, and I quote, I proposed two other suggestions. The first was advocated by Sir Burton Hall some years ago, is to provide in legislation the option of trials by judge alone to persons charged with offenses such as murder and manslaughter. This can also be done now. The second suggestion, which I apprehend abolitionists to find unpalatable, is a more aggressive approach by the prosecution to apply, in appropriate cases, the imposition of the death penalty on conviction of murder. Can we also not do this now? So, Mr. Deputy, I end with this. I agree with the comments made by the member for Cat Island and Rumkey when he spoke in October of 2011. And I end with this. Until our system is fixed, however we tweak the Bail Act will not prevent the grant of bail to persons charged with serious offenses. The only answer to this vexing question is to be able to try persons in a reasonable time. This is the long and short of it. Thank you very much, Mr. Deputy.
Thank you, Honorable Member.